Bismillahirrahmanirrahim. I am Muhammad Islam. Today's topic is about Kanun Shahadat order. Today we will discuss who is a competent witness and number of witnesses. It is very important topic for examination point of view as well as for the practical knowledge. Article 3 and Article 17 of Kanun Shahadat order deals with the topic. We will discuss the topic into two parts. Firstly, we will discuss the competency of a witness. In second part, we will discuss that the number of witnesses. As far as the competency of the witness is concerned, mainly Article 3 deals with the proposition, deals with the topic. Every person who is associated with the legal system, this question comes in his mind that whether child is a competent witness, whether a person of extreme old age is a competent witness or not, or whether any person having any disease of body or mind is a competent witness, whether a person who is deaf and dumb is a competent witness or not. Article 3, in a very simple manner, simply has resolved this issue and has given the proper answer. Basically, Article 3 has provided a principle, has provided a yardstick to determine the factum that who is a competent witness. Principle is this, that every person is a competent witness if he understands the questions put to him and able to give the rational answers. Now, it means that basic principle is the understanding of questions and giving the rational answer. Every person, whether it is a child, whether it is a person of extreme old age, or whether person of having disease of body or mind, if he is able enough to understand the questions and give the rational answers, then he will be considered as a competent witness. For example, if a person appears before a court, judge asks a question, where are you standing? If a person gives the answer that he is in court, he is standing in front of judge, in front of court, then it means that the person is able to understand the answers and is able to give the rational answers. However, if a person is standing in a court and he gives the answer that he is in bazaar, he is in school, then it means that he is unable to understand the questions. In a basic yardstick, basic principle, criteria is this, that the person appearing before the court is able to understand the questions put to him and give the rational answers. Now, coming towards the child, whether child is the competent witness or not, this is the criteria. What method will be adopted, we will discuss. We discuss what method will be adopted. When the child will appear before a court has to make an inquiry while putting certain questions. What type of questions? Whether what's your name, where are you, why you visited the court. If a child gives the answer that he is in court and he has to visit the court, he is in courts to give the evidence, then it means that he is able to give the answers, and he is able to understand the questions put to him and able to give the rational answers. Then court will declare him as a competent witness. Same will be in the case of extreme old age person. Now, the question will come in your mind that whether such kind of queries will be made part and parcel of the record or not. Yes, it will be made the part and parcel of the record, that the court examines the witness, court made an inquiry and declared that witness is a competent. Because if the person is not competent, if the person is incompetent, then then his evidence will not be recorded, because that evidence has no value at all. That evidence has no value at all. No question will come in your mind whether lunatic is a competent witness or not. It is very basic principle that if a person is permanently lunatic, then it is understood that he will be unable to understand the questions or give the rational answers. Then person who is in permanently lunatic, permanently mental, he's not a competent witness. However, if a person, because in so many cases there are lucid intervals, and the person appears before a court, and at that time he is not in lucid interval, and the court makes an inquiry while putting the questions, and if he gives the rational answers, then he will be declared as a competent witness. No, question is this, whether deaf and dumb are the competent witnesses or not. Deaf and dumb are the competent witnesses if he will be able to understand the questions put to them or give the rational answers. Now the question is this, that what procedure will be adopted to record the evidence of the person who is deaf and dumb. In this regard, court has to get the assistance of an expert, because everywhere the special schools are posted in every tehsil, at the district headquarters, special education schools are available, and in such like cases court has to call a teacher, because the teacher who is teaching the kids deaf and dumb, will be considered as expert in this field, and the evidence of the deaf and dumb will be recorded with the assistance of expert. And in this scenario, court also will take oath from the expert. And court will also take oath from the expert. Reason behind that, if oath will not be taken from the expert, then how it can be presumed, how it can be concluded that the expert is giving that same answers that the deaf and dumb person is explaining. So in such situation, court will also take the oath from the person deaf and dumb as well as the expert. So deaf and dumb persons are also the competent witness, because the basic principle, basic criteria or the yardstick is the only one, that if the person is able to understand the questions and to give the rational answers of these questions, then he will be considered as a competent witness. No question will come in your mind that whether evidence of a child witness possessing sufficient understanding has an evidentiary value. However, if a child witness appear in a delicate case matter, then it is the safe to get its corroboration. Now coming towards that, whether any kind of the exceptions of this general principle, yes. Though a person is able to understand the questions and give the rational answers, but if the person appearing before a court as a witness is convicted one by a court for what? For perjury or giving false evidence, then he shall not be considered as a competent witness. The basic principle is the same, but law has provided an exception. Law has provided a restriction on the person who is the convict for what? Not convicted in any offense, rather just in perjury or of giving false evidence. Reason behind that, if the person once has been declared as a false person is used to, then it will be presumed that it might be is used to give the false evidence. However, again another proviso has been provided, that if the person satisfied the court for what? That he has repented and mended his ways, in the person who was the convict of perjury or false evidence, if he satisfied the court that no, he is repentant, he is ashamed of this act, he is ashamed on his deeds, then he will be, court can consider that person as a competent witness. But the discretion lies with the court, because court has to satisfy it and the witness has satisfied the court. Now question is this, what is the qualification as per the injunctions of Islam? Firstly, court has to search the witnesses as per the principles narrated by the Holy Quran and the Sunnah, as per the principles narrated in Islam, in the injunctions of Islam about the competency of the witness. However, if the such witnesses will not available, then court can take evidence of a witness who is available. For example, as per the principles of Islam, in certain cases the evidence of the witnesses who is the pious person, fulfills the principles of tazkiyatu shahud. However, if that kinds of persons are not available, then the person who is available will be considered as a witness if he understand the questions and give the rational answers. Now coming towards the number of witnesses. Article 17 also explains the number of witnesses as well as the competency. Article 17 again explains that the competency of a person to testify and the number of witnesses required in any case shall be determined in accordance with the injunctions of Islam as laid down in the Holy Quran and Sunnah. What is that? In all the matters of hudud cases, hudud and qisas, such as zina, if the court has to convict someone in the murder cases as a qisas, or any other hudud cases, qazaf, in all such kinds of cases, the Islam has provided the principles regarding the number of witnesses and the competency of the witnesses. As far as the number of witnesses are concerned, there are the 4 number of witnesses. And for the purposes for to convict someone in hudud and qisas cases, the number of witnesses are 4, and it is only the male. And evidence of the female is not considered in the hudud and qisas cases. However, it is not the only condition, the number of witnesses. Rather, there is also the condition that the person must be pious and should be the persons who is fulfilling the principles of tazkiyatu shahud. If the witnesses are the same who are the number in 4 and are the witnesses are fulfilling the principles of tazkiyatu shahud, and they are the pious, they are used to offer the prayers regularly, they have not committed any kind of major sins. These are basically the primary principles that court has to take into consideration while considering that person is the person who can be concluded about it. It can be determined, it can be concluded that person is the such who is the able enough, who comes in fulfill the requirements of tazkiyatu shahud. No question is this, that if no such person is available, and it is unfortunate and unless in Pakistan any kind of cases could not be concluded on the basis of hudud and qisas, then whether in such situation the witness could not, in such situation case could not be succeeded, in such situation accused could not be punished. It is not so. Rather, law has also provided other principles. We will discuss in one by one. Firstly, coming towards it is one thing is clear, where no 4 male persons fulfilling the requirements of tazkiyatu shuhud, then there will be no punishment in hudud and qisas cases. Then there will be, however, the offender will be convicted in that cases on the principles of tazir, but not in hudud. Person will be convicted on the principles of tazir. No coming towards the, we will categorize what kind of evidence will be. We will categorize the matters into two categories. One is the financial matters or the future obligations. Another one, all other matters. Firstly, coming towards if there will be any financial matter or future obligation. Firstly, it's reduced so writing. The instrument shall be attested by two men or one man and two women. And if there will be instrument in writing and the instrument is pertaining to financial or future obligations, then there must be two male witnesses or one male and two women, one man and two women. Same principles has also been provided in Article 79. When the agreement has to be, how the agreement to sell could be established, any agreement financial obligations could be established by producing the two marginal witnesses. Or even if the matter is not included, if the matter is not in writing, even then if the matter is about the financial or future obligations, then the principle it is mandatory for the party to substantiate his case, that he has to prove his case while producing the two male witnesses of that transaction, or one male and two female. If such witnesses will not be produced, then the person will fail to prove his case. No question would come to your mind that what is the logic behind that, or what this principle has been implemented. In fact, this is the principle that has been enunciated in the Holy Quran by the God. And this principle of evidence of two male witnesses or one man and two women is available in the Holy Quran, so we can't deviate. What is the reason? Because if one female will forget any facts, then the other will remind him. And what will be the evidence? What will be the procedure of evidence in case of two female about the one transaction as per the Article 17? One is standing in front of, the other will be on his back, and the first one is telling the facts to the court. And if he will forget any facts, then the other will guide him, that other will remind him that fact. This is in fact the method, this is in fact the principle, this is in fact the way to record evidence. As far as all other matters is concerned, the court may accept or act on the evidence of one man or one woman or such other evidence as the circumstances of the case may permit. I hope you all have understood the topic. Who is the competent witness? Every person is a competent witness if he is able to understand the questions put to him and able to give the rational answers. Second one, in case of Hudud cases, must be evidence of the male witnesses. It must be 4 in numbers, and it must be fulfilling the conditions of Tazkiyatu Shahud. As far as the financial matters are concerned, it must be the evidence of the 2 male witnesses or 1 man and 2 women. And in all other matters, evidence of 1 man or woman is sufficient as the circumstances of the case. I hope all your questions or queries have been answered. Even then, if you have any query, you have any question, you can ask in the comment section. Thanks.